is there room to amend that agreement to something that doesn't give it supervisory powers over GECOM
But
as was probably misinterpreted?
it it will be for those who broker that agreement to comment on that. But like any other agreement, it's not cast in stone, and one has to look at the objective of the agreement. The objective of the agreement was not to superimpose CARICOM on GECOM, but was to get CARICOM and GECOM to work together, or GECOM to carry out its mandate in the presence of CARICOM. That was the objective. And once that objective is achieved, formulation of language and linguistic formulations can adapt and adjust to achieve that objective. So that's not, I don't foresee that as a problem. But the chairperson in her submissions made it very clear that CARICOM was simply there to aid and abet the process, not to dominate or subvert the, usurp the function of GECOM. That was not the purpose, and she didn't understand it to be that purpose, and that was important. How did GECOM view the process? GECOM didn't feel, at least through the mouth of the chairperson, did not feel that CARICOM was in charge of the process. They knew that they were in charge, but CARICOM was there to participate and ensure that the process was being carried out in accordance with law, simply because of the peculiar circumstances which enveloped the issues, being that the RO was misbehaving and elements within the secretariat were not acting in a manner that in the way that they should be acting or should have acted.
Mr. Jonas said did the clients he represents do not want Mr. Mingo there. What is there to remove Mr. Mingo from the
Well,
the recounting process?
Mr. Mingo will not. Mingo doesn't have to necessarily play a part of the tabulation process. I have repeatedly referred to the exceptional powers that GECOM has, both in the Constitution and under the Election Laws Amendment Act. The full court, in its ruling, alluded to those expansive, wide, and embracing powers. So GECOM can make any arrangement, can exclude Mingo, substitute someone for Mingo, or get independent people altogether to conduct the exercise once it is done with the authority of GECOM. The Constitution also says that GECOM can delegate, properly so, any of its functions to any duly authorized person that GECOM sees fit and proper. So Mingo being there is not requisite, not necessary. And I would support the view that Mingo should stay as far away from any electoral process as possible, because he has demonstrated that he doesn't have the integrity to carry out that exercise or any such exercise.
Mr. Nandlall, did you address your attention to one of the points raised in the GECOM chairman's court documents that essentially left the door open for GECOM to consider declarations by the chief elections officer towards a final declaration? Did you address your mind to that point?
I didn't see that as an opening. I saw a commitment by GECOM. I saw a recognition by GECOM that the declarations made by Mingo on the 13th of March were tainted by allegations of illegality and lack of transparency and lack of compliance with the laws and the Chief Justice's ruling. I saw that. I saw a commitment by GECOM not to act upon those declarations. I saw a commitment by GECOM not to act upon the report prepared by Keith Lowenfield based upon those tabulations, and I saw a commitment from GECOM to recount the ballot so that not to use those tabulations because of the taint that is attached to it.
But she did say either recount or to accept the report by the chief elections officer. Those were two clear options. She said in the court document.
I don't remember that clear divide. She may have alluded to that possibility. She may have alluded that they can go in that direction, but my reading of her submissions and my reading of her public document, public statements, my reading of her undertaking all lead me to the inference and to the conclusion that she's moving or she wants to move and GECOM wants to move in the direction of a recount, and they were going to move in that direction but for the injunctions granted by Justice Holder, which injunctions have now been discharged.
The decision now does not affect the 230.
No, but the 230 matter can be overtaken if Justice Claudette Singh gives effect to her undertaking and her public commitment. Because what the 230 matter is about, as the matter filed by Jagdev and Holadar, the intent of those proceedings simply is to get the returning officer's declaration made on the 13th set aside and for a recount to be done. That's the main objective of those proceedings. And if we can get those objectives achieved through GECOM itself as expressed via the chairperson, then we don't even need those proceedings. But of course, we are bound to come back here this afternoon because we have to show respect to the process of the court, and we will be here this afternoon to see how this one unfolds. But it's no longer of great moment once GECOM is there, uninjuncted now, and is prepared to proceed to do its job, which is it has committed to do.